Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, while we've all been spun up on pistol braces and everything going on in all the crazy state legislatures around the country, along comes the Fifth Circuit with a ruling last week as it related to those who were accused of domestic violence and had been prohibited from possessing firearms. Now, that had a lot of people here, both in the YouTuberverse and in mainstream media, completely freaking out. A lot of people got in front of their cameras and started talking about how this was the end of days for certain without actually sitting down and reading the entire opinion. We resisted the opportunity to jump on that and decided, we'll take our time, we'll read through the case law, digest it a little bit, and then give it to you in perhaps a manner that you can more easily understand. So today, let's spend a few minutes and talk about what the Fifth Circuit's ruling on domestic abusers really means now and moving forward. Okay, so the issue we are talking about today is United States v. Rahimi, a case out of the Fifth Circuit of the United States Court of Appeals. Now, this case has a rather sordid history, and one of the things that my law professors taught me many years ago, go Gonzaga, is that oftentimes bad facts will make for bad case law. And this case may ultimately prove to be one of those, because I want you to understand who Mr. Rahimi is, okay? I think we all need to understand some of the facts of this case, because yes, he was accused, not convicted. He was accused of domestic violence and was placed on a domestic violence no contact order, which prohibited his possession for firearms. And yes, I will acknowledge that all of this occurred without a finding of guilt against Mr. Rahimi on those domestic violence allegations. However, with that order in place, and these are facts that Mr. Rahimi himself stipulated to as truthful, the following occurred. Between December 2020 and January 2021, Rahimi was involved in 5 shootings in and around Arlington, Texas. On December 1st, after selling narcotics to an individual, he fired multiple shots into that individual's residence. The following day, Rahimi was involved in a car accident. He exited his vehicle, shot at the other driver, and fled the scene. He returned to the scene in a different vehicle and shot at the other driver's car. On December 22nd, Rahimi shot at a constable's vehicle. On January 7th, Rahimi fired multiple shots in the air after his friend's credit card was declined at a Whataburger restaurant. Now, Mr. Rahimi ended up pleading guilty to multiple counts of 18 USC Section 922 G8, although he had originally challenged the constitutionality of it. That matter was previously ruled upon using the pre-Bruen 2-part analysis. After getting convicted, Mr. Rahimi raised another appeal saying, hey, I want this constitutionality of Section 922 G8 reviewed again, this time using the Bruen analysis. This is how the Fifth Circuit put it. The question presented in this case is not whether prohibiting the possession of firearms by someone subject to a domestic violence restraining order is a laudable policy goal. The question is whether 18 USC Section 922 G8, a specific statute that does so, is constitutional under the Second Amendment of the United States Constitution. In light of New York State Rifle and Pistol Association v. Bruen, it is not. Okay, so what the court basically said is that this section, 18 USC Section 922 G8, is unconstitutional, and there was many grounds upon which they will. We're not going to get too deep into the woods, but this is what I want to talk to you guys about today. Let's talk about what this opinion does. Let's talk about what this opinion doesn't do, and then we need to talk about the big 200-pound gorilla in the room that I don't think anyone is willing to touch when it comes to issues such as this, when we're talking about pre-trial conditions placed upon domestic abusers or other people accused of violent crimes. Okay, what this case does do is it rules for any jurisdiction inside the Fifth Circuit that 18 USC Section 922 G8 is unconstitutional. Arguably, you have a lot of other people in that circuit right now being prosecuted under that, and inevitably this case is likely going to be appealed to the United States Supreme Court. More interestingly, what you will probably see is you will see similar appeals in other circuits, including out here in the Ninth Circuit where I reside, and I can assure you that the Ninth Circuit is not going to issue a similar ruling. Once we have an inconsistency of circuit opinions, the Supreme Court is almost mandated at that point. It's almost necessitated that they actually accept review of this. Now, where the government keeps coming down is hey, listen, even if we give Bruen a really, really expansive reading, even if we give Heller a really, really expansive reading, those protections are only afforded to lawful, responsible gun owners, not unlawful, irresponsible, or dangerous individuals. And they pulled language out of both the Bruen and the Heller opinion that suggests that. Now, it could have been in dicta, but certainly that is how the authors of both those opinions referred to the citizens that were being protected by the Second Amendment. Let's talk also about what this case does not do. What it does not do is it does not negate these similar laws all around the country. And for those of you who reside in states, for example, here in Washington State, we have RCW 10.99.040, mandatory conditions of release for those that are accused of domestic violence. We also have RCW 9.41.800, right in our firearms section code, which talks about mandatory relinquishing of firearms and concealed pistol licenses if you are charged with violent felonies or any crime of domestic violence. This ruling does not at this time overrule or strike down any of those statutes. So any statutory scheme that you may have in your state, especially if your state is outside the Fifth Circuit, are clearly still intact today. Let's also talk about, and this is really, really important, the other thing that this case doesn't do, because this case doesn't say that states can prohibit people accused of domestic violence from possessing firearms. What this case states is that unlike in individuals that get convicted of felonies, where they're actually tried by a jury of their peers and then found beyond a reasonable doubt of that crime, therefore they are placed into a prohibited category. What's occurring here is that a person is being placed into a prohibited category based upon allegations and a finding of probable cause, a much, much lower threshold of proof than proof beyond a reasonable doubt. And so in many ways, it is the quantum of proof, the quantum of evidence that is being used to deprive the individual of this right that this court is taking exception to. Okay, and now we have to talk about the 200-pound gorilla in the room, because in the post-Bruen world, as we have seen both state and federal government attorneys trying to advance the cause of gun control legislation, we have seen the desperation in which they have gone to try to find historical analogs to support modern-day gun control legislation. As the court put it, in trying to weed out these historical analogs, the burden falls upon the government in this way. Whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that burden is comparably justified, are central considerations when engaging in an analogical inquiry. Courts should not uphold every modern law that remotely resembles a historical analog, but doing so risks endorsing outliers that our ancestors would have accepted. The core question is whether the challenged law and the proffered analog are relevantly similar. And of course, the government offered all sorts of historical gun control regulations. Now, the court obviously was not persuaded by any of them. The one that they were perhaps closest to being persuaded by was the surety system. Now, the surety system is an old English common law thing where if you believe a person is likely to commit a crime or could pose a danger to somebody else, that they would then be required to post a surety bond, post money, and if they did ultimately end up committing the crime or being accused of committing the crime, they would have forfeited the money. The big analogical difference, of course, is that that person was still not disarmed, okay? In this situation, based on the allegations alone, the person is being disarmed. Why are they being disarmed? Well, they're being disarmed because the law believes them to be a dangerous individual with a propensity to commit violence upon a specific individual. Now, that brings us to the 200-pound gorilla in the room, okay? Because when these government attorneys are going back and looking for historical analogs, the truth of the matter is there is a rich history going all the way back to colonial times, okay, before we even declared our independence, before we even ratified our Constitution, before we ever ratified the Second Amendment, before we even began to think about federal gun laws. There is law after law after law that has prohibited individuals from possessing firearms based on the fact that society deems them to be dangerous. The problem for the government's attorneys is that every single one of those laws is based in one thing and one thing only, and that was the color of that individual's skin. You see, there is a rich history in the United States of restricting firearms from individuals that society deems to be dangerous or unfit. The problem is that many of those laws were actually passed to prevent armed uprising of people who were slaves. And even after the Emancipation Proclamation, state after state after state continued to pass laws because they deemed that one particular segment of their society was too dangerous to possess firearms. So the government's attorneys do have the ammunition to at least make an argument that there is a rich historical analog of restricting firearms from people that society believes to be dangerous. The problem is in doing so, the United States government is going to have to admit that gun control, in its very formation, in its very essence, the genesis of gun control in the United States is rooted in racism. Listen, you may have more questions about United States v. Rahimi, what this means to you moving forward, or anything else related to what's left of our Second Amendment rights. And by now, you guys should know the drill. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.